Ladies and gentlemen, welcome to Civil Justice Subcommittee for March the 19th, 2025. Madam Clerk, please take the roll.
Mr. Chairman, you have 7 members present. You have a quorum.
Thank you, Madam Clerk. Members, do we have any personal orders today? I've got a personal order. We have a deadline to file bills, and each year our legal staff work extra hard on these things, and they're all weekend long. And then we got amendments throughout the year that they have to go through and file, and they help us do so much around here. And I just want to take a minute to thank them because And I got something a little extra special they do not know about because there's so much pork in government. I brought them some bacon, some world's famous bacon from Madisonville to give them some good pork for helping us keep bad pork out of this legislation. So thank you. You're welcome. You'll have to let us know how that is. So. All right, members, let's go over this calendar real quick. Without objection, item number 1, House Bill 1097, rolled 1 week. Item number 2, House Bill 826, taken off notice. Item number 4, House Bill 1301, rolled 1 week. Item number 6, House Bill 1287, rolled to the firearms calendar, March the 26th, next Wednesday. Item number 11, House Bill 487, rolled 1 week. And item number 12, House Bill 1127, rolled 1 week without objection. And Representative Todd, you recognize?
Thank you, Mr. Chairman. Now, understanding that Representative Shaw wanted to take item number 9, House Bill 1012, off notice. Is that correct?
That is correct. I was trying to make it here to carry Mr. Chairman. Thank you for the consideration, but we'll take that bill off.
Thank you, Representative Shaw. Without objection, item number 9, House Bill 1012, taken off notice. That brings us to item number 3, House Bill 1271 by Leader Cochran.
Motion.
We got a motion and a second. Leader Cochran, I show an amendment. Would you like to go with that?
Yes, sir.
Yes,
sir, Mr. Chairman. I've got 004260.
That's what I'm showing. Do we have a motion and a second? We got a motion and a second. Members, let's go ahead and add that on. We're voting to add 004260 to House Bill 1271. All those in favor signify by saying aye. Opposed, no. The amendment's added. And Leader Cochran, you're recognized.
Thank you, Chairman and committee. And so, yeah, this one is pretty straightforward. We have just ensuring that it's the official policy of this state that there are only 2 sexes, a biological male and a biological female, and ensuring that the policies of our agencies, state subdivisions, and any political subdivision that their policies and procedures reflect that biological reality.
Thank you. And members, could we go out of session to hear from testimony first? Do you have any objection to that? All right, without objection, we'll go out of session. And I show a Finn Shilpeck. You'll come down, and also a Joanna Kellen, if you'll come down. And you'll see a microphone there that's got a little red light on it. If you'll just identify yourself, and if you represent anybody, please tell us who you represent, and you'll have 3 minutes, and we will let you know when it's up. So you're welcome to begin anytime.
Great. Okay. Thank you. Good afternoon, Chairman Russell and esteemed members of the Civil Justice Subcommittee. Thank you for giving me a chance to speak on this bill. My name is Finn Shilpeck, and I'm a resident of Davidson County, and I have a master's in medicine, health, and society with a focus on health inequities in diverse populations. While reading HB 1271, I had a few concerns as a scientist, but first and foremost as someone who lives in Tennessee. I'm worried that this bill will target specific Tennessee residents, widening an existing access, privilege, and generally a socioeconomic gap. I am concerned about the burden that this places on local governments who are already stretched thin with their existing resources. Punishing them by adding additional labor and restrictions will not make Tennessee an easier place to live, but rather a more challenging place to sustain and provide equal protections under the law for all residents and visitors alike. To this, I would like to ask whether the true costs of introducing and enforcing a bill such as this have been considered. Does this bill specifically target larger cities in Tennessee while disregarding smaller and less resourced counties that would be further punished by having resources removed? I'm concerned about the impact on local government, large and small. It seems most likely that larger counties have the language that would be affected by this bill, but would small counties be the ones to suffer the consequences of these limitations, such as limited access to funding or grants that utilize the language in this bill? How does this bill and the enforcement of it prevent a vicious cycle that will only target and harm the people of Tennessee? Overall, this prevents the furthering of innovation and safety of living in Tennessee. As a scientist, I would be remiss if I did not address the falsities on which this bill is based. While I recognize the presence of this language in previous legislation, it disregards immutable, reliable, and internationally well-regarded research. Such research proves that there are natural variances in sex, whether they be genetically or anatomically. These variances occur in all species and are not special to humans. Yet, this regard for such natural variance is. This bill, accompanied with this language, will create roadblocks in innovation, local and state level support, and perpetuate the inequities within levels of care available to Tennessee residents, setting us further behind the rest of America, let alone the world. Thank you.
Thank you. And we'll go ahead and hear testimony from you, and then we'll open it up for questions.
Yes, sir.
Thank you.
My name is Johanna Cohane. I'm from Robertson County. So thank you, Chair, Committee, and sponsors for allowing me to speak. I'm a woman. I identify as a woman. I appear as a woman, and I am genetically a woman. I know for a fact I'm genetically a woman because when I was born, I had a medical condition so commonly found in males that the doctors told my parents I would need a genetic test to be sure I was female. My parents were confused because looking at me, I was female. There was brief discussion between my parents and the doctors about what the results could mean and what the next steps would be. The doctors discussed that if the results came back genetically male, they would recommend raising me female and being aware of the gender-affirming care that would be necessary. In a discussion recently with my mom, she said if I had been male, she would have raised me that way to match the genetics, which would have resulted in even more invasive gender-affirming care. We never had to worry about that because the genetic test came back female, matching with my appearance, and I was just one of the lucky 2% of females that had this. But the fact that the test was necessary and that there was debate about how to raise me depending on the test results and what next steps would be show that this is not as simple as this bill presents. Statistics show that 1.7% of the population is identified as intersex. They're a tiny part of the population, but still part of it. What does this bill tell them? When you have 15 or 20 or however many bills per legislative session, you're wasting one on this bill, which does nothing to help the people of Tennessee and seeks to isolate those who do not fit into that category. You're playing identity politics and feeding culture wars with this bill, not seeking to resolve a problem or improve the lives of Tennesseans. There is also a portion of the population that identifies as transgender. We have ideas of male, we have ideas of female, and there are people who identify with those to varying degrees. It appears to me this bill is seeking to address gender by using sex. You cannot, however, regulate people out of existence. They will still be there. If I may suggest, it would be a better service to the people of Tennessee to issue a study by TASER or something similar, reaching out to organizations that serve the portion of that population that would be affected by this bill and seek their input. Again, I'm speaking not for myself, I'm a woman, but I'm speaking for my friends, my neighbors, my coworkers, and a portion of the population of Tennessee that this bill is seeking to isolate.
Thank you, Ms. Cohane. And Representative Johnson, I got you on the list first. You're recognized. And y'all can go back to the fourth there discussion.
Thank you both for being here. I'm going to ask you questions. Sorry, you don't get to run away so fast. You as a scientist and you with the condition that you were born with, I think it's really important that we talk about individuals are more likely to have one of the categories I'm going to mention of intersex people, then they are likely to have red hair. And this is a fact. And I'm sure there are more intersex people than there are transgender people. But you can be born appearing female, but have 5-alpha reductase deficiency and grow a penis at age 12. This is why so many times doctors wait until puberty to decide whether to do surgeries if needed or whatever. You can be born legally male with an X and Y chromosome, but your body is insensitive to androgens and you appear female. Androgen insensitivity syndrome is a condition that affects sexual development before birth and during puberty. You can be born legally male with an X and a Y chromosome, have a penis and testes, and a uterus and fallopian tubes. 3 types of Swyer syndrome. An individual is born legally male with an X and Y chromosome, but your Y chromosome is missing, and the SRY gene, which gives you a female body. An individual is born legally female with 2 X chromosomes, and one of the X's has an SRY gene, which gives you a male body. Number 3, an individual is born legally female with 2 X chromosomes and also a Y chromosome. The individual has a male body. This child would be intersex. You can be born legally female with 2 X chromosomes, but your adrenal gland doesn't produce enough cortisol and your body develops as male. You can be born with 2 X chromosomes and XY chromosome, and that's about, let's see, that is one more example of folks who are not going to fit into these categories. And as I said, according to science, that we see more of this than we do of redheaded individuals. So what are your concerns there? What do you think would be the determination in these types of situations?
Yeah, I think that's an incredibly fair question, and I appreciate you bringing that to the table. I think something to consider with that is, I mean, to your point, a lot of the isolation of populations and what it means to focus on that and framing it as a welfare issue when it targets specific populations versus supporting all of Tennessee as a whole. I think that's a challenging thing to think about and consider, is saying, you know, are we serving all of Tennesseans, or are we isolating a certain half and not qualifying them as Tennesseans anymore because we're taking these aggressive measures against them? And yeah, to your point, it is less of the population than people who have red hair. You know, the chances of walking through this building and seeing someone who has red hair versus walking through this building and seeing someone who's maybe transgender or intersex, they're different. And yet we're not targeting redheads with legislation.
Right. And many of these people, I believe, have lived their life without having to identify this to the world. But this is going to put them in a situation where they have to talk about their health, which should be personal and private.
Absolutely.
I would add that I've never been bothered by people who just want to live their lives. That's never been a problem. But this bill would take a community that already has added concerns that I've never had to worry about and that many people in this room have never had to worry about, and it's going to add to those concerns. And there are very few things in this world that is black and white, that is a clear dichotomy. Very few things. And there's no reason to look at sex as something that is not found normally. We have darkness, we have light, and we have dusk, and we have dawn, and we have varying degrees of a lot of different things. And I don't see this as any different.
And what was the test?
They had to do a genetic test.
So genetic testing,
yeah,
it was required. So
it was required. Even though I'm female, I look female, I am female. So every indication that they could have looked at besides genetic testing said female because I was female, but they had to do a genetic test to be sure.
Right. And so for all of these folks, that would be the situation as well. So thank you all so much for your stories.
Thank you. And I don't have any further questions, but we do want to thank you both for being here today, and we appreciate your testimony. So thank you.
Thank you.
Thank you. Members, without objection, we're going back in session. And Representative Cochran, you're recognized.
Thank you, Chairman and Committee. And just to, I think one important part to highlight is that, our state has already defined sex. This bill is essentially going a step further to ensure that we have enforcement mechanisms that our agencies are complying with the definition that our state has already passed into law some time ago.
Very good explanation. And Representative Johnson, you're number one on our list.
Thank you. So what is the impetus of this bill? We have definitions. We've heard of all the people that are not going to fit into this, and without genetic testing, you don't know the answer to whether they're male or female. So I'm curious, if you say we already have definitions, why are you bringing this legislation? It's curious to me, and I'd like to know what the impetus is.
Representative Cochran, you're recognized.
Right. Well, once again, the impetus is to ensure that we have an enforcement mechanism of those definitions. Currently, there's not. Yes, we do have definitions in state law. This is to ensure that our political subdivisions and our state agencies are going by those definitions in law when they are making public policy for the people of Tennessee.
Representative Johnson.
Are we going to require genetic testing for everyone? Because of there are more intersex people than there are redheads?
Representative Cochran.
This bill is not about genetic testing. It's about policy making for public bodies. And when those agencies and political subdivisions are making policies for the subdivisions and for those agencies, it is ensuring that they are acknowledging biological fact that people are male or female.
Representative Johnson.
But did you hear the instances I read when someone may present as a female but are not, or someone may present as male but is not because
Representative
of
Cochran.
how they were born?
Sure. And there are biological realities at birth where you are either male or female. And I understand that, that the complicated medical situation occurred. But again, this definition is already in state law. This is making sure that we have an enforcement mechanism for the political subdivisions and agencies of the state of Tennessee.
Representative Johnson.
It can't be enforced without genetic testing. And there are a lot of people that fall outside of that medically, whether you want to acknowledge it or not. So I will be voting against your bill.
Representative Cochran.
Once again, just to clarify, it's not the enforcement on individuals. It is the enforcement for political subdivisions and agencies. There's no genetic testing required for that.
Very good. I don't have anybody else on my list. We're voting. The question's been called. We're voting on House Bill 1271. All those in favor of sending House Bill 1271 to full judiciary signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk.
Mr. Chairman, you have 6 ayes, 1 no.
House Bill 1271 goes to full judiciary as amended.
Thank you, Chairman and Committee.
That brings us to item number 5, House Bill 5 by Representative Bolzo. Do I have a motion? Motion. We got a motion. Do I have a second? We got a second. And I do show an amendment. Representative Bolzo, you still want to run it?
Yes.
What
Mr.
number
Chairman,
do you show?
005443.
That's what I showed. Do we have a motion and a second on the amendment? We got a motion and a second. Let's go ahead and add that. All those in favor of adding 005443 to House Bill 5 signify by saying aye. Opposed, no. The ayes prevail. Representative Bolzo, you're recognized on the bill as amended.
Thank you, Mr. Chairman. Good afternoon, members of the committee. As we heard last week from our witnesses, Shelley Sumner and Kathy Waterbury, we have a serious problem in Tennessee with abortion pills being illegally sent into the state by out-of-state actors, both from within the United States and from outside of the United States. HB 5 seeks to remedy that, to deter these actors who are acting in a way that's felonious under both state and federal law from sending abortion pills into Tennessee. What HB 5 does is it creates a civil cause of action in favor of the family of an unborn child who was killed by abortion pills being sent illegally into the state against the abortion pill supplier who sent them in to the state unlawfully, and then stipulates that the abortion pill supplier is liable in strict liability. That is, there are no defenses that can be raised that are typically raised as affirmative defenses under Rule 8 of the Tennessee Rules of Civil Procedure. And also that the damages are stipulated to be $5 million as a means of deterring this type of unlawful conduct from continuing to occur. With that, Mr. Chairman, I'm ready for questions.
Thank you, Representative Bolso. And if we got somebody to testify, so without objection, we'll go out of session. And Yarnell Beatty. Yarnell Beatty. And you'll have 3 minutes. If you'll just state your name for the record and who you represent, and we'll start timing you.
Thank you, Mr. Chairman. I'm Yarnell Beatty, and I'm the General Counsel for the Tennessee Medical Association. TMA opposes House Bill 5, Amendment 5443. TMA did offer an amendment coded as 5576, and the Senate sponsor has agreed to run that version and willing to move that. What it does is it does allow for catastrophic damages for wrongful death for this violation. That's $1 million rather than $5 million, but it takes out the strict liability standard. Okay, so TMA objects to the addition of strict liability. If there's an actionable wrongful death action, then an abortion-inducing drug must have been used. Otherwise, how else would there be a death? That means the Healthcare Liability Act is invoked, and that act applies a negligence standard, not a strict liability standard. Also, the act does not cap punitive damage, which is another mechanism to award additional damages if they're proven. Next, TMA opposes the $5 million penalty in contrast to the non-economic damage cap of $1 million for catastrophic loss. The proposed fine is more than 6 times higher than what a plaintiff can presently recover in non-economic damages for the wrongful death of a child in a civil action. So we urge you not to go down the slippery slope of eroding established tort law. Chipping away at existing law imparts uncertainty to current healthcare providers and businesses in Tennessee and will chill future businesses from lawfully operating in the state. And by that, I mean that the $5 million fine and the strict liability standard will likely create shortages of medications that are used to treat your constituents' other medical conditions for lawful uses. So under the extreme penalties, liabilities, inability to assert an affirmative defense, then the manufacturers will refuse to transport some of these drugs into the state at all, even for the lawful purposes. So we ask you not to eat into our non-economic damages law that's working well. It attracts doctors and businesses into the state. And let's not invite unintended consequences of medication shortages based on a law that really isn't needed. So TMA urges you to vote no on the amendment. Thank you.
Thank you, Mr. Beatty. Do we have any, Representative Johnson? You're recognized.
Thank you. So I think what I just heard you say was that there are other uses for these drugs. I think I remember a show, something, an article or something, that's perhaps with lupus or something like that.
Yes, ma'am.
Where people take this drug. They've already had problems in shortages with getting this drug because of this very thing. Is that correct?
That is correct. Yes, ma'am.
Thank you.
Okay, seeing no further questions, Mr. Beatty, we appreciate your testimony here. Thank you. Members without objection, we'll go back in session. And Representative Bolso, you're recognized.
Thank you, Mr. Chairman. Let me just take a few minutes to respond to the points that Mr. Beatty made. I mean, first, he acknowledges that TMA is not just concerned with the amount, but that they took out strict liability, which is a huge problem because under our law, if someone brings a claim, there are certain defenses that can be raised, among others, waiver, estoppel, unclean hands, independent and superseding cause, comparative fault. And absent strict liability, an abortion pill supplier that sends abortion pills into Tennessee is going to be raising all of those defenses against the mother to whom the abortion pills were sent. So if we don't have strict liability, we are going to seriously compromise the effectiveness of the cause of action that we're actually creating and putting in statute. Second, Mr. Beatty mentioned that there's a non-economic damage cap on a case of this nature of $1 million. But once again, that simply is not the case. When we actually look at our statute, and this obviously is part of 29-39-102, subsection H, what we see is that under our existing law, there is no cap of any kind for intentionally wrongful conduct. And if we look specifically at the language of subsection 8, it says the limitation on the amount of non-economic damages imposed by subdivision A2 and subdivision B-E shall not apply to personal injury and wrongful death actions in the following circumstances. Number one, quote, if the defendant had a specific intent to inflict some serious physical injury and the defendant's intentional conduct did in fact injure the plaintiff, close quote. So there is a cap of $750,000 on certain types of injuries. There's a catastrophic cap that Mr. Beatty referred to of $1 million. But where the defendant acts intentionally, there is no cap under our existing law. So in a case of this nature, someone who brought the claim would be able to recover whatever non-economic damages a court or a jury found appropriate, plus the economic damages caused by the wrongful conduct. And typically in a case of this nature, economic damage is far more significant than non-economic damage because typically it's composed of lost earning capacity. So in a wrongful death case, you would actually be able to recover the present value of all of the future earnings of the party who was killed, in this case, the unborn child, reduced to present value, less whatever living expenses would be deducted. That is normally a figure that's several $million. So the idea that somehow this type of a cause of action should be limited to $1 million is not actually supported by even our existing statute. Next, Mr. Beatty referred to the $5 million as a fine or a penalty. That's not it. That's not what we're doing. This is not punitive damages. This is an amount that is intended to deter criminal actors from sending abortion pills into the state. And it's also intended to provide reasonable compensation to the family who lost the unborn child because the abortion pills were sent unlawfully into the state. So the amount, the $5 million that's a stipulated statutory amount, is there to provide for the non-economic damages that could be recovered in the case, plus the economic damages, which is comprised principally of the lost earning capacity for the child's entire life. So it's not a fine or a penalty. It simply is a compensatory award. And the final point that Mr. Beatty made was that the law is not needed. I'd simply ask you to think back to last Wednesday when we heard from Shelley Sumner and Kathy Waterbury, who testified in graphic detail about what their clients bring to them. Young ladies who order these abortion pills through the mail without any medical guidance. They're given no information about gestational age, and they've, in some cases, given birth to live babies in their bathrooms. And then in other cases, of course, you've heard the horrific injuries and the needs for admissions to emergency rooms. Finally, Ms. Waterbury has shared with me the statistics that are available from Society for Family Planning in the We Count statistical category. And the latest statistics for the period January of 2024 through June of 2024, that's a 6-month period, there were 2,620 abortions in Tennessee from abortion pills mailed illegally and in violation of our felony laws into Tennessee. So there is a significant need for this law because we need to deter these companies from continuing to kill unborn children illegally in the state.
Thank you, Representative Bolzano. Any questions for the sponsor? And Representative Todd, you're number one.
Thank you, Mr. Chairman, and I appreciate the sponsor bringing this bill, and I appreciate you also working with different folks that had concerns. And you've clearly laid out the folks that this doesn't apply to, pharmacists, physicians, motor carriers that are delivering the materials. They don't know what's in there. So I think you've done a really good job to answer the questions that folks have had about this, and I fully support it. Thank you, sir.
Representative Bolzo, any follow-up?
Thank you, Mr. Chairman. Thank you, Chairman Todd.
Okay, next on my list is Representative Travis, and we'll go with Representative Johnson after that.
Thank you, Mr. Chairman. And Chairman, a question I'm just concerned on with, I'm not clear on, is that some of these drugs are used for something else.
Yes.
They're like, I heard somebody say lupus or something, but they are used for something else. How do we determine these people that are shipping this? How do we determine if it's used for abortion or another medical situation?
Representative Bolzo, you're recognized.
Thank you, Mr. Chairman. This way, Representative Travis, if it's not used for an abortion, then there will never be a cause of action, because this bill that we're looking at only applies when an unborn child has been killed by the abortion pills having been sent into the state.
Representative Travis.
Yeah, thank you. Okay, that's great. But one more question is, like, let's say this grandmother is taking this medication for a procedure, and the granddaughter gets into it and takes a couple of those pills and aborts a child. How does that count into the equation? Because that could happen, you know.
Representative Bolzo.
Thank you, Mr. Chairman. This way, Representative Travis, when you look at the statute, it makes it clear that the defendant violates the statute by sending an abortion-inducing drug into the state, quote, to a patient, close quote, via courier delivery or mail service. So this is only going to apply to an abortion pill provider who sends the abortion pills directly to the patient, to the expectant mother.
Representative Travis. Next up is Representative Johnson.
Thank you. Yeah, I guess we heard from the Medical Association, that the Tennessee Medical Association, that their concern is about it being available. And I know that only in this cause of action, could that happen? But what it does is put a chilling effect on those sending the medication at all, as I understand it. Does that concern you at all, that other folks with lupus and other things that need this medication, that there will be a concern about shipping it at all? It seems to be the Medical Association believes there will be a problem.
Representative Bolzo.
Thank you, Mr. Chairman. The short answer, Representative Johnson, is no. That is not a legitimate concern, because when you look at the bill, we specifically use the term abortion-inducing drug. And that is a term that's actually defined in the Abortion-Inducing Drug Risk Protocol Act that this body passed in the 112th General Assembly in 2022. And when you look at the definition of abortion-inducing drug, and specifically this is 63-6-1102, subsection 2, an abortion-inducing drug is defined in part this way, quote, does not include drugs that may be known to cause an abortion that are prescribed for other medical indications. And so anyone who is ordering what would otherwise be an abortion-inducing drug for some other medical indication, such as lupus or a miscarriage or something else, is not at all covered by the statute.
Representative Johnson.
Okay, I guess what we have to be realistic about is there is a relationship between the medical community and the legislature. And because of laws that we've passed, there are people who will not come practice here. We are seeing a 20% drop in OBGYN residents coming here because of legislation we've passed that is very aggressively going after physicians. So I think that the fact that it exists is what causes the problems for anyone. You can say that's not in the bill. However, that has a chilling effect on others. And I think we have to be intellectually honest that that is actually something that is happening in Tennessee.
Representative Bolzo.
Thank you, Mr. Chairman. Let me just respond this way, Representative Johnson. If in fact our laws criminalizing abortion is having the effect of OBGYNs or residents not coming to Tennessee who want to perform abortions. I think that's a good thing. I think the law is doing what it's supposed to do. We do not want physicians in Tennessee performing abortions because that's the unlawful taking of an innocent human life, and it's just a horrible thing.
Representative Johnson.
Well, no one wants to perform abortions, but sometimes in order to save women's lives, they need to do that. And they know that they cannot in Tennessee, or they will have to prove that they were saving a life to folks who aren't doctors. And so to pretend as if this is something someone goes into being an OBGYN for is so disingenuous. The reason people go into this is to help women. But Tennessee is a state that forces a 10-year-old to carry a pregnancy at the risk of dying at 2 times greater than an adult pregnant woman. And then we're not going to have OBGYNs coming here for caring for the people that you were forcing to carry pregnancies. And it's just incredibly, it's incredibly disingenuous to make the statements that you're making and assume that people go into being an OBGYN so they can perform abortions. That's disgusting and inoffensive.
Representative Bozo, would you like to follow up?
Yes, thank you, Mr. Chairman. Perhaps Representative Johnson, we can agree on this, that no one wants abortion pills being sent directly to an expectant mother in Tennessee without the supervision of any type of medical professional, which is what is going on now every day across the state in each of our 3 grain divisions. And that's what this bill is designed to stop. So regardless of how one feels about the issue of abortion generally, nothing good comes from companies unlawfully shipping these abortion-inducing drugs directly to an expectant mother who by herself is taking them. And as we heard Shelley Sumner say last week, quote, self-managing an abortion, close quote.
Representative Garrett, you're next.
Thank you, Mr. Chairman. Thank you for Chairman Bulzo for this piece of legislation. I know it's got, this. My question to make sure, I think you said it, so I think you answered it. But want to make sure that any lawful purpose for this particular drug is not affected. You indicated that it has to be used in effect to induce an abortion. Therefore, if it's used for any other purpose that's lawful for what the drug's supposed to treat, there's no action. There's no standing. The next of kin, the wrongful death, it doesn't exist without that particular instance of it being used for the purpose that your bill is for. So if indeed that's the case, which I think you would agree with me that that's what your intent is, would you be opposed if this goes forward to making sure that's absolutely clear in the piece of legislation that it would accept to any lawful purpose? I'm not sure if your piece of legislation has that in it, but would that be something that you would consider if and when this travels through the system to make sure if it's used for a lawful purpose, then there's obviously no action?
Representative Bolso.
Thank you, Mr. Chairman. Yes, Representative Garrett, we certainly would be open to that because the way that we've included the limitation of these drugs specifically to abortion is by incorporating the term abortion-inducing drug, which is a defined term in the Abortion Drug Risk Protocol Act. But we could certainly very easily add language to make it even more explicitly clear that this only applies to drugs sent into Tennessee for the purpose of aborting an unborn child.
Representative Garrett, any follow-up?
Thank you, Mr. Chairman. Thank you, Chairman Bowles, for clarifying that. I appreciate it.
Representative Travis, you're next.
Thank you, Mr. Chairman. Chairman, just got one more question. With the bad players that are involved in this, let's say the mother and the father, they're going to do an abortion. It's just set in stone. They're going to do an abortion. So somehow they get this drug mailed into them, and then they have the abortion. And then all of a sudden they say, hey, I can get $5 million by suing this company for doing that. What's going to keep that from happening, or is there anything we can keep that from happening?
Representative Bolso.
Thank you, Mr. Chairman. And let me just answer the question this way, Representative Travis, just focusing on the mother, leaving the father out of it for just a second. Our law and our policy has always looked at a young lady in a crisis pregnancy as a victim, not as a perpetrator. We have never made any attempt to criminalize her in any way or to take any other action against her. I completely support that policy. And I think we apply that policy here, that if you have a young lady who's in a crisis pregnancy, I mean, she is in a very vulnerable state, and that state should not be exploited for profit by these out-of-state abortion pill providers who are only interested in sending pills to Tennessee so they can make money. So yes, if we had a young lady who in a moment of crisis ordered and used these, and then she later decided that she was a victim and had been victimized by these out-of-state abortion pill providers, she is someone who can bring a cause of action under this statute. And we look at that as being an important part of the statute because that, among other things, will particularly deter the out-of-state abortion pill suppliers from sending them in because they'll know if this becomes law that the very patient to whom they're sending these drugs, who's in a very vulnerable state, physically, mentally, emotionally, probably otherwise, could at some point decide she was taken advantage of and bring this case. So that is perhaps a feature of the statute, not a loophole in any respect.
Representative Travis? Any other questions? So I've got a question. This applies to the supplier that sends an abortion pill to a patient. Is that correct?
That is correct, Mr. Chairman.
What happens if the patient gives the pill to a third party and they take the pill for an abortion?
In that circumstance, there would be no liability on the abortion pill provider because this only applies to abortion pill providers that send it to the patient. If a patient gets it and does something else with it, that's going to be beyond the scope of what's in this bill.
Thank you for clearing that up. Members, I don't have anybody else on the list. We're voting to send House Bill 5 to full judiciary. All those in favor signify by voting aye. Opposed by voting no. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 1 no.
Thank you. And sponsor, your bill goes to full judiciary.
Thank you,
As
Mr. Chairman.
amended.
Thank you, committee.
And without objection, we will take up item 8. Representative Bowles has been here for 2 weeks straight. That's House Bills 571. We got a motion and we got a second, and I do show an amendment. Representative Bowles, would you like to move forward with that?
Yes, Mr. Chairman, I would. And the drafting code is 004451.
We got a motion, and do we have a second? We got a second. Members, we're voting to add 004451 to House Bill 571. All those in favor signify by saying aye. Opposed, no. The amendment added. And Representative Bozo, you're recognized on the bill as amended.
Thank you, Mr. Chairman. Members, this is a bill that I'm carrying for Senator Janice Bowling, who has already filed and is moving this bill in the Senate. It deals with an issue that we dealt with before, which is protecting the privacy and security of women and girls in private spaces. This House Bill 571 does one thing. It requires facilities in 4 different categories to segregate changing areas, showering facilities, restrooms by sex. And the 4 categories are: number 1, domestic violence centers; number 2, public schools; number 3, correctional institutions; and number 4, juvenile detention facilities. So what this bill does is in all 4 of those types of facilities, it requires multi-occupancy restrooms, showering facilities, changing areas to be segregated so that women and young girls have privacy so that they're not exposed to members of the opposite sex, biological boys who identify as women or girls being there. There's also exceptions that obviously deal with emergencies where obviously first responders have to come in to address an emergency, or you're dealing with a family or things of that nature. And with that, Mr. Chairman, I'm ready for questions.
Thank you. And we have somebody here to testify. Elliot Certain. Without objection, we'll go out of session. And if you'll come up and take a seat or you can stand at the podium, whichever you want to do. And if you'll state your name, if you represent anybody, state that, and then you'll have 3 minutes.
Thank you, Mr. Chairman and members of the committee for allowing me to speak today. My name is Elliot Certain. My pronouns are he, him, and I'm proud to be a transgender Tennessean. I sit before you to speak in opposition of the bill that was just introduced, HB 571. This bill is not about safety. It is about exclusion. Under the guise of protecting women, HB 571 seeks to codify rigid, outdated definitions of sex that fail to account for the existence of transgender people like me, your constituents, your neighbors, and your fellow Tennesseans. It singles out transgender and non-binary individuals for discrimination and attempts to solve problems that do not exist while making life harder for everyday Tennesseans. This bill talks about the community that comes along with being a member of one's sex, but there is also a community to be found in one's gender. As a transgender man, I know many transgender people in my community who would be severely negatively impacted by this bill. Ignores the fact that transgender people are far more likely to be the victims of violence rather than the perpetrators of it. On average, transgender people are 4 times more likely to be the victims of domestic violence or intimate partner violence. It also disregards the well-documented harm that comes from forcing people into spaces where they do not belong based on biology rather than lived identity. Let's be clear, this bill will not only harm transgender people, it will also endanger cisgender women, women who are born female, who do not conform to traditional stereotypes. A cisgender woman with short hair, wearing masculine clothing, or with a more androgynous appearance may be challenged, harassed, or even removed from a restroom or shelter simply because she does not look feminine enough. Women who have survived cancer and lost their hair, female athletes who have more muscular builds, and countless others who do not fit these outdated ideas of femininity may find themselves being accused of being in the wrong space, or worse, be forced to prove their biology before they can access help. This bill invites the policing of all people, increasing discrimination and discomfort for cisgender and transgender people alike. Members of this committee, you were elected to serve all Tennesseans, not just some. You have a duty to protect the safety, the dignity, and the rights of every person in this state, no matter how narrow definition you go by. Transgender Tennesseans are part of your communities. We are your neighbors, your colleagues, and your constituents. And today we are asking you to do your job, to represent all of us. A vote for this bill is a vote to make life harder for the very people you were sworn to serve. A vote against this bill is a vote for fairness, equality, and basic human dignity. If this legislature values public safety, it should focus on policies that actually prevent violence, funding domestic violence services, expanding access to mental health care, and improving protections for all vulnerable populations, including your transgender Tennesseans. HB 571 is not about protecting women. It is about policing gender and making life harder for transgender people and any person who does not conform to rigid gender norms. I urge you to reject this bill and stand for the dignity, safety, and rights of all Tennesseans. Thank you.
Thank you. Any members have any questions? Representative Johnson, you recognize.
You mentioned the violence that transgender people experience. Could you talk more about that? Like, do you have numbers on that?
Yeah, absolutely. So in the state of Tennessee, we, or I don't have state of Tennessee specific numbers, but from JAMA Network Online, 47% of transgender men, people like myself, have reported experience intimate partner violence in the past year. And then that correlates to 18% of transgender women and 16% of non-binary individuals. And this is percent greater than their cisgender counterparts. So 47% greater than those who identify the same as they were born. Transgender people are also 4 times more likely to experience violent victimization than their cisgender counterpart individuals. Transgender people experience 86.2 victimizations per 1,000 people, whereas cisgender people experience 21.7 victimizations per 1,000 people from the Williams Institute. So we are at a higher risk of victimization, not a higher risk of victimizing.
Okay, and what what percentage of people are transgender? Like what is part of the population are we talking about?
So in the United States, it's 1.6 million people. That may sound like a lot, but like you said earlier, it's about every time you see a redhead, that's about the 1 to 2% of the population is the generally agreed upon statistic of finding how many people in the United States identify as transgender.
Okay.
And of course, it is a spectrum. Some people identify as trans, some people identify as gender fluid. It's different for a lot of people, but the risks are still the same.
Thank you.
Thank you. And I don't show any further questions. We appreciate you being here today. We always appreciate hearing from the public. So thank you so much.
Thank you.
Members without objection, we're back in session. And Representative Bolzo, recognized. The question's been called, and I got one objection. Voice vote. All those in favor of previous question signify by saying aye. Opposed, no. The ayes prevail. We're voting on House Bill 571 to send to full judiciary. All those in favor signify by voting aye. Opposed, vote no. Has everybody voted? Does anybody member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 1 no.
571 prevails as amended. Full judiciary. Congratulations, Representative Bolzo. Come back next week. It gets better.
Thank you, Mr. Chairman. Thank you, committee.
That brings us to item number 7, House Bill 904. We got a motion and a second and a second. And I do show an amendment, Representative Gant. We got a motion and a second. Would you like to give us a number so we can make sure we get the right one?
Sure. The amendment number is 004350.
That's what I show. We got a motion and a second. Members, we're voting to add 004350 to House Bill 904. All those in favor signify by saying aye. Opposed, no. The amendment's added. Representative Gant, you're recognized on the bill as amended.
Thank you, Chairman. This bill would give an administrative judge another option to consider when trying to determine if a person is owed attorney's fees from a contested case hearing involving the ABC, which we call the Alcohol Beverage Commission. The bill would allow the judge to award the fees if the person prevails in an administrative action brought against the person by the commission and the fees and cost incurred as a result of the administrative action. Mr. Chairman, I move passage.
All right, the sponsor moves passage. Any questions? Seeing none, we're voting to send House Bill 904 to full judiciary. All those in favor signify by voting aye. Opposed, no. Has every member voted? Does any member wish to change their vote? Madam Clerk, takes a vote.
Mr. Chairman, you have 7 ayes, 0 no's.
The ayes prevail. 904 goes to full judiciary as amended.
Thank you, Chairman.
You're welcome. Come back and see us. All right, that brings us to the end of the calendar. Without any further business, we will be adjourned.